Good afternoon, everyone, and welcome to the Banco Court of the Supreme Court of New South Wales. It's a great privilege to be present here this afternoon in this significant institution to whom we are partnered in our bicentenary. Can I take the opportunity to extend particular thanks to the Chief Justice and everyone here at the Supreme Court for hosting us this afternoon and making it possible for the conference to move here to the legal precinct. This afternoon, our very special panel will discuss and explore New South Wales's first Chief Justices and the early pathways they forged for Australian case law. Of course, we've already heard this morning how critical one of those early Chief Justices was to the inclusion of the establishment of the Legislative Council in the New South Wales Act. We'll now hear about how important he and others were to the development of law in New South Wales. It's my great privilege to be able to introduce to you the Chief Justice of New South Wales, together with former Justice Virginia Bell and former President of the New South Wales Court of Appeal, Keith Mason. Andrew Bell was admitted to the bar in 1995 and appointed Senior Counsel in 2006. His Honour was appointed President of the Court of Appeal on the 28th of February 2019 and then elevated to Chief Justice on the 7th of March 2022. After a succession of academic achievements at the University of Sydney and a Rhodes Scholarship to Oxford, he became one of the foremost experts in Australia on private international law and transnational litigation. Following 7 years as a solicitor with the Redfern Legal Centre, Virginia Bell was appointed to the New South Wales Bar in 1984 and was appointed a senior counsel in 1997. Between 1994 and 1997, Virginia was counsel assisting the Royal Commission into the New South Wales Police Service. She was appointed a judge of the Supreme Court of New South Wales in 1999, judge of the Court of Appeal in 2008, and she was appointed to the High Court of Australia in February 2009, where she served until her retirement in February 2021. Keith Mason has been a solicitor, barrister, law reformer, Solicitor General, President of the New South Wales Court of Appeal, law teacher and mediator. He has published on topics including judicial method, legal taxonomy, the law of restitution, and the interface of law, morality and religion. Currently an adjunct professor at the University of New South Wales and President of the Appellate Tribunal of the Anglican Church of Australia, he is also, of course, an esteemed colleague and friend of the Legislative Council, serving as our respected and revered independent legal arbiter, as he has done for many years. Please join me in welcoming our esteemed panel. Thank you.
Thank you, David, and welcome everybody. This is, as David has said, the Banco Court, en banc, the French legal law French, for the full court. This is our ceremonial court where new judges are sworn in, where new legal practitioners are admitted. You might be interested, surprised or alarmed to know that there are almost 3,000 new lawyers admitted every year. And that happens generally on a Friday once a month with 5 ceremonies a day. In any event, we had one of those last Friday. But this is also the courtroom which, when I sit on the Court of Appeal or on the Court of Criminal Appeal, we sit here. So it's an active courtroom. It's not only a ceremonial courtroom. One of its features you'll see from looking around at the portraits there are portraits of 14 of the 18 Chief Justices of this court in this courtroom, starting immediately behind you with the first 5 judges: Sir Francis Forbes, Sir James Dowling, Sir Alfred Stevens, Sir James Martin and Sir Julian Salomons. And then we have an hiatus because Sir Frederick Darley, the 6th Chief Justice's portrait, although painted long before this building was built, is too big for this courtroom. So we jump, and then some of you will know, and I'll mention a little bit later, we have this unusual feature of the Supreme Court of New South Wales, that there has been 3 generations of Chief Justices from the Street family. Sir Philip Street, Sir Kenneth Street, and most of you in the audience will remember the lately departed Sir Lawrence Street. None of the Streets are in this courtroom, either because their portraits too are too big for it, but they are hanging some in the vault above the steps, the 2 sets of steps leading into the court. But the other Chief Justices, other than myself, because a sitting Chief Justice does not have his or her portrait painted while sitting, but all of my other predecessors are in this room, and you can imagine sitting on a case, they look at you from all directions when you ask an obtuse question or something goes wrong. But their inclusion in this building, it has been commented on as being quite significant, because you will know from this building's, the external features of this building, that it's fairly brutalist. It's not a terribly warm building, but it's very modern in the mid-70s when it was built. But it has been commented that the hanging of these historic portraits of the former Chief Justices unites the traditions, the historical traditions of this court in this state, formerly this colony, into the new building, so it represents a sort of continuity. And I also say, because it's true, at these admission ceremonies once a month, we still wear these traditional robes, which I can tell you are not comfortable, but we say, or I say, at the admission ceremony, that we wear them for a symbolic reason, namely the continuity of the rule of law. And next year, as you know, in conjunction with the Legislative Council, this court will celebrate its 200th anniversary. It is, in point of fact, one of the oldest continuous courts in the world. And we are both proud of that and looking forward to celebrating its history. I thank David and his team at Legislative Council for including the court in this important conference. Now, the way we're going to proceed is as follows. Keith Mason will lead us off. Keith is, apart from his many other achievements, is also the lead author and editor of the forthcoming history of the Supreme Court, the 200-year history, which I'm told is now tracking at about 450 pages. It will be a major publication. We expect it will be published in February or March next year, in time for the actual bicentenary, which is the 17th of May, the bicentenary of the first sitting. Obviously, the Charter, we know when the Charter was executed, and then the first sitting about 6 or 7 months later. Unfortunately, 7 days after the first sitting of the Supreme Court of Van Diemen's Land. And so that court, now Supreme Court of Tasmania, claims seniority over New South Wales, which we do not wholly accept. So Keith is the lead editor and principal author of the history, and Virginia has written a marvellous chapter on leading criminal cases. So Keith is going to lead us off, picking up from the Charter and talking about some of our first Chief Justices. We'll then continue, and we also reserve the right to interrupt each other, which I fully expect we'll do. And there'll be questions at the end.
Thank you. The title given to this whole conference, as you know, is the Spark, the Act that brought Parliament and the Supreme Court to New South Wales. This morning, Brett Walker poured a deal of cold water on the notion that the 1823 Act brought executive accountability, let alone democracy, to New South Wales. But he hadn't really read the title because it spoke about bringing Parliament and the Supreme Court to New South Wales. I do want to thank the framers of this conference, but acknowledge that they made a more moderate claim than Brett accused them of mistaking. Perhaps I should apologise for having a bit of a jab at Brett. I've known him since he was 6. He was my pupil at the bar, but more importantly, he and I appeared on opposite sides of the record in the case of Egan and Willis, which decided that the Legislative Council had authority to require the government to produce papers, a very significant development in the constitutional history of this state and of the council. I suppose I should acknowledge he was on the winning side and I represented the government of New South Wales at the time. In another very technical sense, the title or the subtitle, the Act that brought the Parliament and the Court to New South Wales, is misleading. Both of these institutions were really created by a form of delegated legislation. The 1823 Act, by Section 1, authorised the Crown in England to constitute the Supreme Court by charter or letters patent under the Great Seal, and by Section 24 authorised the Crown by warrant executed under the signed manual to constitute the Legislative Council. So those acts of actual constitution took place subsequent to, but under the authority of that statute. The Legislative Council was, as Lynn Lovelock adverted to, a little bit of an afterthought. The main drafting of the 1823 Act was done by Francis Forbes and James Stephen. Stephen was at that stage the senior lawyer in the Colonial Office. He served there for many years and ended up being head of the Colonial Office well into the middle of the 19th century. But Francis Forbes, who I'll mention a little bit about in a few minutes, was on leave in England. He'd been given the nod that he would be made the first Chief Justice of New South Wales, and he and James Stephen set about drafting the legislation that became the 1823 Act. The vast bulk of provisions in that Act deal with the court, and some of them in quite technical ways. It said that when the court is set up, it'll have this power and that power. It did so by investing this court, and it still is this court, the one that was constituted under the authority of the 1823 Act, investing it with the powers and jurisdiction of all of the main royal courts in England at the time. So the jurisdiction of the Court of King's Bench, Exchequer, Common Pleas, and the Lord Chancellor were all tipped, as it were, into the jurisdiction of the Supreme Court. And that was the legal foundation for the authority of this court to exercise justice, to administer justice in criminal and civil matters of any import, and also to hold the executive accountable under the then quite embryonic system of administrative law, which of course is much more significant nowadays.
Can I just cut in? It also provided for a house for the Chief Justice and said that the Chief Justice could be referred to as the Supreme Justice of the Supreme Court. But both of those binding historical legislative matters seem to have fallen away.
Put not your trust in princes. One of the triggers for what became Section 24, the provision that gave the Legislative Council its power, in effect, to make law, was a belief that the well-founded belief that the governor did not have sufficient authority to do anything that would change the law of England. Legal doctrine said that when the white settlers arrived, they carried with them magically in their baggage as a birthright the state of English law as it existed at the cut-off time, and it was originally thought to be 1770. It was later updated and brought forward to 1824. But this notion that the extant English law, to the extent that it was applicable, just automatically flowed into the colony once it became a British colony. But, of course, laws need constantly renewing, and Parliament amends the common law all of the time. And as early governors started saying, well, how about we have a duty on these imports, or how about we make this regulation for dealing with currency or bills of exchange or convict discipline, people started saying, well, hold on, that's a bit of a twist, a bit of a difference from what the English law was in 1788. What authority do you have to do this? And therefore, it wasn't so much a democratic consideration. It was a concern to have proper authority for the lawmaking power of governors. So a legislative council whereby the governor still did everything, but with the advice of these nominated officers, was the means whereby legislative authority could be exercised. But because there wasn't thought there'd be much call for this, it was only very late in the piece that James Stephen persuaded Forbes to set to and draft what became Section 24. There are only two of the 45 sections of the Act deal effectively with legislative matters. The rest are all matters concerning the court. There is excuse me, there's a picture of the scroll which has the Act of Parliament, as you can see. In those days, Acts of Parliament were handwritten. They were put onto a vellum scroll and rolled up. There was no internet or any other form of access to the legislation. For a while there was a bit of a proposal being explored as to whether the people in Britain would allow that precious document to be brought out here for the bicentenary, but I gather that has not come to fruition for various reasons. Had it been, I had a proposal. I couldn't persuade the Chief Justice to do it, but the proposal was that the document would be cut in half, and the two sections dealing with the Legislative Council would be on display on the other side of Macquarie Street, but the big scroll would be here, but that hasn't come about. As I said, the Act authorised a Charter of Justice to, in effect, get the Supreme Court going and make provision for it, and that charter was executed by the monarch on the 13th of October 1823. It's known as the Third Charter of Justice because there were courts in New South Wales before 1823. They were let's say they were doing the best they could. Some of the judicial officers had no legal training. The judge advocate, as he was called, drew up the charge, put it to the accused, conducted the evidence, listened to any arguments, and then pronounced judgment. So it was not an ideal type of court system, and so clearly there was a need for something better, and that is the Third Charter, which you can see also on the screen. That document is available and will be part of the display for our bicentenary. It was proclaimed here in Sydney on the 17th of May 1824, and so that establishes the anniversary date. Francis Forbes has been mentioned. He was an inspired choice as the founding Chief Justice of New South Wales. He was born in Bermuda, called to the bar at Lincoln's Inn, served in Bermuda as Attorney General before taking the post of Chief Justice of Newfoundland. So this is the notion that Professor Garton was telling us about of the various empire connections. As I said, while on convalescing leave in England, he began an enduring association with James Stephen in the Colonial Office, and the two men collaborated in the drafting of the legislation. Forbes was the first Chief Justice and for a time the only judge of the court, and from the outset administered the full extent of civil and criminal justice in the Supreme Court from 1823 onwards. He didn't just do his judicial work extremely well, but some of his rulings laid the groundwork for the rule of law in this country. I won't go into any particular details, but one aspect of the power of the royal courts in England was to supervise administrative actions of magistrates and officials, and Forbes' court quickly got about doing that and regulating some aspects of executive action. So again, in a slight fine-tuning of what Brett said this morning, while the Parliament wasn't armed with any real power to put the governor in check, the court was, and quite soon it got about doing so, and quite soon there was conflict between Forbes and Darling, which I'll come to very shortly. Forbes was a man of fairly conservative views, but considerably more liberal and more committed to the rule of law than Governor Darling and the exclusives like MacArthur, whom Darling listened to. There were some particular things done by Forbes in the area of freedom of speech, for which the court, the nation, is grateful. He really laid the groundwork. Some of his rulings in early cases where newspaper people were being prosecuted for seditious libel for writing critical, often sarcastic and ugly, but nevertheless critical articles about the governor and things the governor and the governor's men were doing. The governor would then instruct the Attorney General to have them tried for seditious libel, and occasionally they were found guilty and sent to jail. Forbes consistently directed the juries, which, as you've heard, consisted often of officers under the command of the governor, that they firstly had to act as if they were ordinary jurors back home in England. That was possibly a stretch, but a stretch in the right direction. And that they had to recognise that freedom of speech was very important. One of the powers given to Forbes under the 1823 Act was to certify in advance of whether any legislation put before the Legislative Council was consistent with the laws of England, a rather broad formula, and it was one that Forbes didn't particularly want to have, but the power had to be somewhere. The governor had, as you've heard, authority to initiate legislation, and in effect he had the numbers, and if the Legislative Council didn't do what he wanted, well, he didn't have to assent unless he was overridden back home in England. But following the governor's defeat in a couple of seditious libel trials against the editor of The Australian, Darling came up with the idea that he would have legislation enacted that would require the press to take out a licence. Forbes advised the governor formally under the power and under the Act that this form of censorship in advance was not consistent with the law of England, and he was in that case dealing with the spirit of the common law in England. Darling then said, all right, well, I'm going to tax the papers, and introduced a bill for a prohibitive tax. Forbes said, no, you can't do that either, because that breached the English principles as well as a specific principle in the Act. Now, so Forbes had multiple roles. He was a judge, he was a member of the Legislative Council, he had this specific role as Chief Justice to, in effect, certify whether any law was consonant with English law. He also was invited to sit on the Executive Council when that was constituted. He didn't like doing that. Besides, he had a lot of things on his plate, but he did that. And he had this specific power under Section 29 of the 1823 Act to certify legislation, which led him to conflict with Governor Darling. Now, just before I finish, there were a handful of matters that were. I'll just say something about the Stephen clan. I mentioned Sir James Stephen, who was the senior legal man in the Colonial Office when Forbes was working with him, but he rose to become the head of the Colonial Office. His uncle, John Stephen, who is, I think, the second from the left in that picture, became the first puisne judge of this court. Puisne meaning next after the Chief Justice. Lately born, I think is the law French. But so he was Uncle John to James of the Colonial Office, and he served with Forbes as the second judge in the court, arriving a year or two after Forbes. John Stephen's son, Alfred Stephen, pictured in the middle, became the longest-serving Chief Justice of this court, serving between 1844 and 1873. Sir Alfred Stephen also served in the Legislative Council. For a while, judges were appointed to the Legislative Council in the early years, up until about the 1830s. It got a bit controversial, and so they stopped doing it. After Alfred Stephen ceased to be Chief Justice, he went back to the Legislative Council, and he served as the president of that body for some years, I think in the earlier stage. Alfred Stephen's son, Matthew Henry Stephen, was another judge of this court between 1887 and 1904, and he had a grandson, Edward Milner Stephen, who served between 1929 and 1939. So there have been some dynasties apart from the streets. Some matters provisionally or inadequately addressed in the 1823 Act and the Charter. The juries, you've heard that mentioned. They are dealt with in the Act, but it says that until the Crown in England decides otherwise, juries in criminal matters will be military men appointed by the Governor. And that was a bone of contention, and it was well into the 1830s before the British government relented on that. The Charter provided that convicts could no longer be admitted as legal practitioners. That had been a real bone of contention, and that provision was made. One matter on which both the Act and the Charter were silent was the position of women. It wasn't necessary to do anything about that because the common law was very clear: women were incapable of exercising public office. I imagine Virginia may have something to say on that topic, but that was so clearly the law that no need to mention it. The early Chief Justices, Andrew has mentioned. You may have picked up the fact that being a Chief Justice in the 19th century meant you had a very good chance of having a city street named after you. So we have Forbes, Dowling, Stephen, Martin and Darley streets. There's no street named after Sir Julian Salomons, the one on the far right, but I think the Chief Justice will mention in passing why that was so. He was only Chief Justice for a matter of days. The idea of naming streets after judges fell into disuse in the 20th century. I suspect it had something to do with the fact that in the 20th century there were 3 streets, and to have a street would be a bit redundant. Thank you.
Thank you, Keith. Well, Sir Alfred Stephen, the man in the middle, and that's a photograph as quite an old man, as Keith has said, actually went back to the Legislative Council after he retired, having served more than 30 years as Chief Justice, and he lived till he was about 90, and he spent 20 odd years still active in the Legislative Council. He was succeeded as Chief Justice by Sir James Martin, after whom Martin Place is named. Martin had spent 20 years prior to becoming Chief Justice in politics, but in the lower house, and he had, as a young man, agitated for representative democracy, and he was elected to the Parliament, I think about 1850, and was in and out of government for the next 20 years, served as Attorney General in various governments, including that of Sir Henry Parkes, with whom he had various fallings in and fallings out. And he also was Premier on 3 separate occasions in the late 1850s and the 1860s. Martin's story is a rather remarkable one. Appreciation of it has been enhanced in recent years by the establishment of what's called the Lysicrates Foundation, and certainly within the legal community there's much more interest in Martin's incredible life story. He came as an infant to Australia, aged 18 months. His father came out to be the groom to Governor Brisbane, so he grew up in the grounds of Government House in Parramatta. He was precocious as a child, student. He was a prodigious reader. He became initially a journalist, writing for the Australian, and then he edited at an early age the Atlas newspaper. He was robust. He said of his predecessor, whilst he was a young man, he said of the Supreme Court judges, in fact, some allowance we admit ought to be made when we consider the manner in which our judges have hitherto been selected, and when we see persons elevated to the bench who, in point of talent and legal knowledge, are inferior to the majority of those who plead before them. He said the inclinations of Chief Justice Stephen were towards despotism. In any event, Martin was an entirely self-made man. He was very conscious of his relatively lowly status. He aspired to status. He grew influential as a journalist and wealthy as a barrister, and with that increasing wealth, his influence, including his political influence, increased, but there was some resentment, some continuing resentment from the tail end of the exclusives that he was a parvenu, that this self-made man was precocious, obnoxious. Bede Nairn, well-known historian, describes him as having a rare combination of lowly birth, pugnacity, colonial patriotism, ability and growing wealth. And he became the dominant lawyer for a period overlapping with his time as Premier and Attorney General. He continued to act as a lawyer while holding both of those offices, so he was regularly appearing in the Supreme Court in front of Sir Alfred Stephen and others. So there he is. He's described. That portrait is has been described as showing him as a rotund figure. He had a large personality. He was he had been a significant legislator. He'd been one of the original sponsors, as it were, for the University of Sydney Act and the Mint, the creation of the Mint, and following the gold rushes, very significant nation-building role, and he continued and then finished his career a period of more than 10 years as Chief Justice. He really is one of the most significant in terms of all-round ability and contribution and interest, a really very significant figure, and one who was, although conservative in his political bent, he was also strongly meritocratic. and extremely patriotic in the sense that he was a champion of this emerging country. When he retired, William B. Daly, whose statue is in Hyde Park, if you know where Macquarie's, the relatively recent statue of Macquarie is, just across from Queen's Square, there's a sort of a green, faded copper sculpture of a statesman in between Macquarie and St Mary's Cathedral, and that's W.B. Daly, who was a great statesman and I suspect bon vivant of the late 19th century. He declined the Chief Justiceship, as did Sir Frederick Darley. Now, I'll come to Sir Frederick in a moment, but this is where Salomons came in. So Salomons, the small portrait up there, and you see in the screen, Salomons was a barrister. He was a well-regarded barrister. His appointment was welcomed by the Sydney Morning Herald and the Bulletin, but other newspapers were less enthusiastic. He was Jewish. I don't think that was the reason he changed his mind. I don't think it was necessarily an anti-Semitic reaction to his appointment, although there has been debate over the years as to whether that might have been the case. But more so, it was Windeyer, who Virginia will speak about in a more favourable light, who appeared to psych him out. Windeyer was a judge, was probably hopeful for his own preferment as Chief Justice, and he told Salomons that he didn't think Salomons was up to the job, and Salomons had something of a crisis of confidence. And so, even though his appointment was gazetted on the 13th of November, he resigned 6 days later. Darley was then prevailed upon. Darley, having been earlier asked and said no, was prevailed upon to take on the position, and he did, and he had a long tenure all the way through from until 1910. So for Keith, so yes, from 1886 until 1910. So he was the second longest, but I know this is a conference of historians or people with historical interest. You might be interested to know that in 1893, Sir Frederick Darley, as Chief Justice and Lieutenant Governor, entertained in Sydney none other than the Archduke Franz Ferdinand of the Austro-Hungarian Empire at Government House, some 20 years before the latter's assassination at Sarajevo. Now, the Archduke Franz Ferdinand was out visiting for a spot of marsupial shooting. He went kangaroo, koala and emu shooting in the Hunter Valley and was accompanied by his own personal taxidermist. Anyhow, the Australian marsupial community no doubt felt a sense of collective karma or schadenfreude when Gavrilo Princip was to hit his mark, albeit at closer range than the marsupials, on the afternoon of the 28th of June 1914. Sir Frederick Darley was the Chief Justice in the period leading through the convention debates for the Australian Constitution and the Commonwealth. He was there to welcome the Governor-General Lord Hopetoun on the creation of the Commonwealth in Centennial Park, I think, is where the official ceremony took place. But he did not support the existence of the High Court, which was established in 1903, and there was a great deal of resentment from the incumbent Supreme Courts around the various colonies at this new court. It wasn't initially warmly welcomed. It was seen as an incursion on the status and the significance, the historical significance of the Supreme Courts. It was poorly funded. It wasn't actually established until 1903, so it wasn't established immediately, and there was some tension, and that tension has ebbed and flowed over the years, although, of course, the High Court's role at the apex now is very well and firmly established. Now, only briefly, Sir William Cullen succeeded Darley. Cullen is over there, the first on the left, but Cullen had an instrumental role before taking up the Chief Justiceship with the role of women in the law.
Thank you, Chief Justice. Do I take it you're throwing to me now?
I'm throwing to you.
Well, may I say, I was allocated the subject of women in the context of the judicial work of the Supreme Court over the last 2 centuries. The Chief Justice and Keith have assumed, as is their wont, the lion's share of any discussion of that topic since, of course, until the very late 20th century, women had no part in that work at all. I thought I'd look at 2 areas. Firstly, the impact of the personal qualities of the judge on the hapless women who happen to appear before the court. I am speaking of the work of the court in the 19th century, when it has to be said that the social and political views of the judge were very likely to influence the outcome of litigation in which women might be engaged. Happily, I can say from my experience as a judge of the court in the very late 20th, early 21st century, that tendency seems to have run its course. I also thought I'd look at the struggles of women at the end of the 19th century for reform of laws which so oppressed them, and the recognition by some redoubtable feminists that before there could be effective change, it would be necessary for women to be able to practice law and advocate on their own behalf, and indeed represent constituents in Parliament. Dealing with my first topic, it's necessary to say something about the common law as it stood for much of the 19th century. Women were precluded from participation in vast areas of public and professional life. The legal personality of a woman became submerged on her marriage with that of her husband. In some respects, the law did treat married women as the property of their husbands. Under the doctrine of coverture that applied in the colony of New South Wales, a woman's legal capacity was reduced almost to nil upon her marriage. A femme sole, a woman who was not married, could own property, she could conduct a business, she could sign contracts, she could bring legal proceedings in her own name. By contrast, a femme covert, literally a covered woman, couldn't do any of those things independently of her husband because she was considered one person in law with her husband. Her personal property became that of the husband, though on his death she did have the right to retain her paraphernalia. Her paraphernalia were her clothes and her ornaments. If she had an interest in land, the husband had complete control of it during his and her life, and if he survived her, he could retain an interest in the land for his life, known as a curtsy. Her wages were his, and if he died first, they didn't revert to her, they passed to his estate and were dealt with by his executor. I should just say, one of the happy circumstances of living in a penal colony was the intersection if I can use that word which is so loved by social scientists, the intersection of the common law of coverture with felony attaint. Upon conviction, a felon became civilly dead. He had no civil rights or capacities at law. Hence, if you were married to a convict in New South Wales, you remained a femme sole and you could keep your own property. The restrictions on coverture became more and more untenable as the century progressed. Turning now to William Windeyer, barrister, politician, and subsequently a justice of this court. And to my mind, I have to say, despite any rough and tumble he may have had with Sir Julian Salomons, to my mind, William Windeyer ranks second only to Simone de Beauvoir in terms of his instinctive understanding of the oppression that women were subject to. He led the movement for reform of the law of coverture, and he introduced the Married Women's Relief Bill into Parliament in 1878. That led to fierce debate in the pages of the Sydney Morning Herald, as you might imagine. One correspondent observed of the law, were it to be enacted, she may occupy her time in earning money and may spend it on her own luxury, dress or extravagance, or even drink for that matter. Despite these well-founded fears, the following year, the legislation passed as the Married Women's Property Act of 1879, and a married woman obtained the right to earn money and hold property in her own name. The Act did not in terms deal with her contractual capacity, and that omission came to light in the case of Olivia Mayne. Mrs. Mayne sued two theatrical entrepreneurs, the McMahon brothers, for their failure to pay her the agreed hire of £25 per week for the hire of her boxing kangaroo, called Fighting Jack. The McMahon's barrister argued that while the Act allowed women to recover, protect or secure their personal property, they remain nonetheless non-entities under the common law and therefore couldn't make or enforce a contract. The defence also, as a second line of attack, argued Mrs. Mayne was a woman who ran away to chase money and excitement, neglecting her husband, in an attempt to characterise her entry into a contract as illegitimate, if not actually illegal. She actually recovered from the jury, but the full court set aside the judgment, holding it was altogether too much to read the conferral of the right to contract under the Married Women's Property Act. William Windeyer was undeterred. He relied on the boxing kangaroo case when advocating for further reform of the law. And I just pause to say, it makes you sort of proud to be Australian that when the Married Women's Property Act of 1893 redressed this oversight, it was largely on the strength of vindicating the right to be properly remunerated for your boxing kangaroo. While Sir William is still up on the screens before you, I have to point out he had the discernment to have married and to remain happily married to one of the most notable feminists of the 19th century. Lady Mary Windeyer, who is pictured beside him, was the foundation president of the Womanhood Suffrage League of New South Wales. And I like to think it was her influence, at least in part, that we can divine in Justice Windeyer's most famous judgment, Ex parte Collins. That decision was one of a number of cases in the latter part of the 19th century that dealt with the vexed question of making information available to the public about methods of birth control. There were two cases, Ex parte Collins and 3 years before it, Bremner and Walker. They illustrate the chasm between Chief Justice Martin in Bremner and Walker and William Windeyer in Collins. Going firstly to Bremner and Walker. Thomas Walker was prosecuted for an offence under the Obscene Publications Prevention Act, arising out of his possession of diagrams of the male and female reproductive organs. He used those diagrams to illustrate public lectures on techniques of birth control. He was convicted of obscenity before the magistrate, and he appealed to the Supreme Court, and the matter came before Chief Justice Martin. Chief Justice Martin was a sufficiently good lawyer to see the appeal had to succeed on a technicality. Nonetheless, he devoted some paragraphs in his reasons to explaining why the exhibiting of drawings of this kind was a very serious offence. He drew this distinction. It was one thing, he said, for a professional man to exhibit drawings of this kind to a group of students studying physiology, but quite another thing to do so to the public at large. This, of course, was in line with Sir James' general attitudes exhibited some years earlier in the Legislative Assembly when he opposed the enactment of a matrimonial causes bill, expressing the concern that were it to become an act, it would import the excesses of the French Revolution. Revolutionaries, he considered, were apt to see the marriage tie as of no moment, and he feared for the colony if it should go down that path. By contrast, as I say, only 3 years later, one has Ex parte Collins. William Collins, a young secularist, was charged with distributing one of Annie Besant's pamphlets on family planning. He was convicted by the magistrate, and he brought proceedings in the Supreme Court to prohibit the magistrate from proceeding on the conviction. In his reasons, Sir William Windeyer rejected that any natural function of the human body is obscene in itself. He said there's nothing unholy or unclean about the natural instincts of man. It was the diseased mind of the unnaturally living ascetic with his distorted views of religion that led to God's handiwork becoming the object of shame and disgust. Sir William asked rhetorically, where was the immorality in allowing a woman married to a drunken husband information in order to avert the consequences of her husband's brutal insistence on his marital rights? And then he drew this riposte to Sir James Martin's contrast between the professional man and the members of the public at large. In a very famous passage, he said this: information cannot be pure, chaste, and legal when bound in Morocco at a guinea, but impure, obscene, and indictable in a paper pamphlet at sixpence. The time is past when knowledge can be kept as the exclusive privilege of any caste or class. Now, to move from the sublime, indeed, to move from that high peak of 19th century jurisprudence.
Just interpose for a second. Sir James Martin had, or his wife had, 15 children. And she left him and moved to Vaucluse late in life.
You know, I'm always loath to correct the Chief Justice, but indeed she bore him 16 children, one stillborn.
Right, thank you.
You can't look at the jurisprudence of the Supreme Court in its first century as it affected the interests of women without reference to Justice Hargrave, who has been notably absent from discussion so far. John Hargrave was born in England a few months after the Battle of Waterloo. He was educated at Cambridge and he went on to study law at Lincoln's Inn. Unremitting study was said to have unhinged his mind, and after receiving a legacy, he retired from the bar. Ultimately, his wife had him committed to an asylum. Gradually, he recovered, and you won't be surprised to learn he came to the colonies where he was appointed a judge of the Supreme Court. His work habits, perhaps reflecting a concern lest he should lose his mind a second time, in my view, have always served as an example to all judges. He acknowledged that he rarely commenced sitting before 11 a.m, and he is reported to have ignored all the complaints that he rarely sat after 2 p.m. He never forgave his wife, and he harboured an unmitigated dislike of women. This made his selection as the first judge in divorce following the enactment of the Matrimonial Causes Act of 1873 somewhat unfortunate. And it was not as though Justice Hargrave's views on women weren't known. They'd been made clear in a series of cases brought by widows challenging their late husband's testamentary capacity. At the time, the law left it to testators to fulfil their moral duty to look after their widows and children. If the husband failed to provide for them, the court could offer no assistance unless it found the husband to have been of unsound mind at the time of making the will. In 1872, Justice Hargraves heard a case brought by Frances Townsend. She challenged her husband's will on the basis that he was of unsound mind and that he suffered delusions as to her fidelity. Despite evidence from several witnesses that he was maniacal and under delusions, Justice Hargrave found the will to be most rational. He went on to chastise Frances Townsend, saying she had ransacked her husband's most secret papers in an attempt to prove at the cost of his only child that his father ought to be considered a confirmed lunatic. On appeal, fortunately, with Chief Justice Stephen presiding, the decision was reversed. It was found the testator suffered from an insane delusion. I just must pause. I sensed the Chief Justice when I was speaking a few moments ago getting restive, and I fear that he's worried that I'm spending too long on my first section.
First section. Oh, yes. Well, I think we could move seamlessly through to the Women's Legal Status Act, could we?
Look,
picking up on the segue from Sir William Cullen, with which I introduced you.
Look, I have to...
Some time ago.
I have to omit an enormous amount of very valuable material for historians, but I'll do so. Well, look, I sense your frustration, but what can you do when you're in the Banco court and the Chief Justice is giving you a kick? I'm going to come to the topic of Ada Evans, the first woman to graduate from Sydney University's law school in 1902, but nonetheless to wait 19 years before she was permitted to be admitted to practice. I should say, and this brings me in a somewhat round or circular fashion to the Chief Justice's prompt, getting access to the law school was no mean feat. The Dean of the law school was Professor Pitt Cobbett, whose name, to quote FDR, should live in infamy. He was not at all happy at the idea of having any female law students, and there's no doubt that Ada Evans would not have been admitted had it not been for the happy circumstance that he had taken a sabbatical in 1902 and was temporarily replaced by the Assistant Dean, then William Cullen. I pause just if I may interpolate one thing, Chief Justice. Sir William also had the discernment to be married to another of the foremost feminists of his day. Anyway, going back to Ada, she commenced her law studies to the evident annoyance of Pitt Cobbett on his return, and she completed them with distinction. There's a report of her graduation ceremony published in the Australasian on the 26th of April 1902. The excitement for the girl graduates was to see Miss Ada Evans presented for the LLB. Professor Pitt Cobbett, who is a bachelor and not partial to women, could not conceal his disapproval as he introduced the interesting-looking girl to the Chancellor, who smiled pleasantly. The paper went on to note that there was no prospect of Miss Evans being admitted to the bar, although after a short rest it announced that she was going to begin agitation for a new act. The paper neutrally recorded that at present every judge in Sydney is opposed to her. The Legal Practitioners Act at the time established a board to approve properly qualified persons for admission as barristers. Evans was advised that an application to the Supreme Court to compel the board to admit her had no prospect of succeeding. Between 1904 and 1917, she wrote to successive Attorney Generals seeking a change in the law. It was not until October 1918 that the Women's Legal Status Bill was introduced into Parliament. In speaking for the bill, Attorney General Hall suggested that New South Wales was lagging behind other states in permitting women to enter the legal profession. He recalled that one woman had passed her examination for admission to the bar at the same time as he had. He graciously acknowledged that her pass was better than his, and he noted that she had occasionally communicated with his department, inquiring when she would be permitted to practice for the profession for which she had qualified herself 17 or 18 years earlier. As enacted, the Act provided that a person shall not by reason of sex be deemed to be under any disability or subject to any disqualification from being elected as a member of the Legislative Assembly or as a member of a local council, or to be appointed a judge or magistrate, or to be admitted to practice as a barrister or solicitor. Ada Evans commenced her apprenticeship as a student at law in May 1919, and on the 12th of May 1921, 19 years after graduating, she was admitted as the first female barrister in New South Wales. Now, don't you push me, I've just got to add this postscript. In June 1921, in a sad postscript, she refused a brief to appear in an equal pay case. She was concerned, she said, not to undermine the standing of women by any show of incompetence, the product of her involuntary 19 years of absence from the law. Chief Justice.
Thank you. Thank you. So it may well be, as still happens today, that the Chief Justice or the Supreme Court is often consulted about legislation. It may well be that Cullen, Sir Frederick Cullen, who was serendipitously the acting dean when Ada Evans applied for admission and before he became a judge, he may well, and my suspicion is probably was consulted about the Women's Legal Status Act of 1918, because he was at the height of his own Chief Justiceship then, and it permitted not only women to practice law and be appointed or to become barristers, etc., but also to stand for council, to become mayors, and to become members of Parliament. It's interesting, Virginia has mentioned the wife of Sir William Windeyer, the wife of Cullen. The trilogy, as it were, lies in the fact that Sir Kenneth Street, the second of the Streets, to be Chief Justice, who I mentioned before, was married to the redoubtable Jessie Street, who many of you will know as a leading feminist and social activist. There's probably something to be made of those facts, or that fact about both their influence on their husbands and their husbands' own attitudes to basic equality and representation. So, conscious of the time, I'm just going to give you a quick Cook's tour through the other judges, Chief Justices, and then briefly something about, we now have, I'm pleased to say, in the court, about a third of our judges of the Supreme Court are women. It's about 40% of the District Court, it's 60% of the Land and Environment Court, and it's 50% in the local court. We've come a long way. But now for the quick Cook's tour. So Cullen was succeeded by Sir Philip Street. He in turn was succeeded by Sir Frederick Jordan, who many people regard as the greatest Chief Justice, a brilliant man, and if you want to read more about him, Keith has written the definitive biography of Jordan, available at all good bookstores. Jordan was, as Keith likes to say, sandwiched by the streets, so Sir Kenneth Street followed. And then, interestingly, for most people, becoming Chief Justice would be the epoch of their career, but the second street was followed by H.V. Evatt, so the third from the end. H.V. Evatt had 30 years before been appointed to the High Court as he was about 30 years old, or 31 or 2 years old at the time. He served on the High Court with great distinction for 10 years. I think 1930 to 1940. He served with great distinction on the High Court for 10 years. He overlapped with Sir Owen Dixon, for example, overlapped entirely with Sir Owen Dixon in that period. And then, of course, he left to go into politics. He played the great role in the third General Session of the United Nations, during which the Charter of Human Rights was passed, and then he went on to his political career. He also argued the Communist Party case, one of the great cases in the High Court's history, with great distinction, and then had a period of time as leader of the opposition. So he became Chief Justice, having achieved all of that. But the reality was the position was really arranged for him. He was in decline. It was a means of moving him on from federal politics, and his time was a rather tragic and brief one as Chief Justice of New South Wales. He was followed by Sir Leslie Heron, who's the very engaging looking man holding a book open in what is, I think, my favourite portrait of the court. He led the court during a very tumultuous time, because the Court of Appeal was established during his time, and it was controversial in the history of the court because the judges who constituted were not appointed in order of seniority, and this caused a huge contretemps amongst the judges of the court, split the court, huge resentment, open antagonism and warfare. The court is now more than 50 years old and is, I think, regarded as one of the great appellate courts in the world, in the common law world. It's had some great judges and has a very high reputation. So Heron was Chief Justice during that period, and also when the Supreme Court had its most significant legislative reform in the Supreme Court Act of 1970. So then, more controversy, he was succeeded by none other than Sir John Kerr. Now, it's not easy. I always think it's not easy to tell whether Kerr's wearing a wig or not. But you can see it's dangling. His full-bottom wig is dangling. That's his great head of hair. One obviously, one's view of Kerr is skewed, however one looks at it, by the events of 1975, but he was a significant Chief Justice. He was very significant in the foundation of Law Asia, which is the sort of Pan-Asian legal body, and that dated back to his work in the Second World War and the Pacific Commission. He was heavily involved in the intelligence agency during the second and the immediate post-war, and had a great interest in the Pacific, and that led to the foundation of Law Asia. And the Supreme Court of New South Wales still plays a lead role in the judicial branch of Law Asia. So Kerr was Chief Justice for I think 2.5 or so years before he became Governor-General. He also was a very, very good judicial administrator and played an instrumental role in not only this building being developed, but also in preserving the heritage courts, which I think you're going to go for a tour of, or some of you might go for a tour of after this session. That's, say, the heritage courts in King Street and St James Road, which the courts which essentially wrap themselves around St James Church. The foundation stone of St James Church was originally the foundation stone of the Supreme Court, but plans changed, and what was to become the court became St James Church, and then other buildings were built around St James Church, which became the court, the first one of which I think was completed by about 1834. Is that right, Keith? Anyhow, you'll have to buy the book to find the answer to that. So just to finish the Cook's tour, Kerr was succeeded by Sir Lawrence Street, who's again too big for this building, but Sir Lawrence was succeeded by Murray Gleeson, who's the only Chief Justice of New South Wales to both go to the High Court and to become Chief Justice of the High Court. Many people think his successor, Jim Spiegelman, could also easily have been appointed Chief Justice of the High Court. He was an outstanding Chief Justice. He was Chief Justice when Virginia, I think, was appointed, and Keith too, I suspect. He of course, had the most fascinating career. He came to Australia at the age of 2. Like Sir James Martin, he came from Poland post-war. At 25, he was Principal Private Secretary to Gough Whitlam. At 28, he was head of the Department of Communications, the Commonwealth Department of Communications. During his time at the bar, he was chairman of the Art Gallery. He was chairman of the Powerhouse Museum. A number of other, chair of the Film Finance Corporation. He was an outstanding barrister. When a law student, he was with Charles Perkins on the Freedom Rides in the 60s, and after his retirement as Chief Justice, served a term as chair of the ABC. My immediate predecessor, Tom Bathurst, is there. He was still is a great commercial and corporations lawyer. I describe his Chief Justiceship as Old Testament, because during it we had a great flood in the building. Some floors were out of action for 6 months because of burst pipes. We had the bushfires. Remember the bushfires enveloping Sydney for months and months, and then we had the pandemic. So we had flood, fire, and plague. But in any event, so just Virginia, why don't you give quick burst about Jane and some of the early female judges,
Right.
because, and then we'll have some questions.
Well, if I could just briefly note, going back to the Women's Legal Status Act, it contemplated that women might become judges and magistrates. It didn't provide for women to serve on juries. That was because the Parliament couldn't cope with the idea of women sitting in judgment on men. The idea of any woman becoming a judge or a magistrate was so utterly fanciful, they didn't worry about enacting it. And that was very wise in 1918. It wasn't until 1987 that Jane Matthews was appointed as the first woman justice of the Supreme Court. Jane had before that served on the district court. She had, in her role as a district court judge, she headed up the then newly established Equal Opportunity Tribunal, and she delivered pioneering judgments on issues to do with what was then the very new concept of sexual harassment. Things speeded up somewhat after Jane's appointment to this court. In 1994, Carolyn Simpson was appointed the second woman justice to the court. Carolyn is still serving as an acting Justice of Appeal. She is the longest serving judge in this court. Again, relatively early on, Margaret Beasley was appointed to the Court of Appeal, the first woman to be appointed as an appellate judge. She then served as President of the Court of Appeal following Keith's retirement, and of course now she serves as our present Governor. I should just add a nice little personal touch, if I'm allowed it. In April 1999, Margaret Beasley, Carolyn Simpson and I sat as the first all-female appellate bench in any common law country. And it was quite a moment.
Thank you, Virginia. So, exquisite timing. We have exquisite timing with most gentle of prompting. We have a little time for questions. I think there's some roving mics. Yes, we don't usually have roving mics in court because we like to confine the questioning to one person in the middle. But we'll make an exception for this audience. So if there's any questions, please feel free to ask Virginia.
Question for Your Honour, Virginia Bell. Do we sometimes get referenda results wrong? Was 70 too early for High Court judges to have to retire?
Well, it's I don't think you intended to, but you are defaming me. The retirement age is 70. I am still only a youthful 72. Look, I mean, the retirement age was fixed in the 1977 referendum. Before that, of course, judges of the High Court, their tenure was for life. I think we've seen in the United States with their Supreme Court why it's not wise to have life appointments. You would know from recent experience it is very rare for the Australian public to support a referendum proposal, but one of the 8 out of 44 that they have supported was forcing a retirement age on federal judges. You can argue about whether 70 is perhaps too young given the life expectancy today as opposed to what it might have been, say, at Federation. But you need a bright line and you need renewal in a court, so I don't myself think there's any real reason to chafe about it.
Yeah, there are two points I'd add. In New South Wales, the retirement age is now 75, and one can come back as an acting judge if invited until 78. So Justice Simpson, who Virginia referred to, I don't refer to that as the drop dead date because that's a little bit, it's not very nice. But that's the end point for judicial service. But as you know, Virginia, for example, did a large Commonwealth inquiry into whether one could hold multiple ministries, unbeknown to anyone else. And other retired judges have conducted inquiries. It's much better to have distinguished retired judges conducting inquiries of that kind than sitting judges. In my view, it happens from time to time. Justice Paul Brereton did the initial Chief Commissioner of the National Anti-Corruption Commission did, of course, the war crimes, but while he was still serving as a judge, and it has happened. Different states have different attitudes to the appropriateness of that. On the whole, it's not appropriate for institutional reasons, although exceptions can be made, etc. But had Sir Anthony Mason not been made Chief Justice, he could still be a sitting member of the High Court at age 98 and a half. He turns 99 next May and is still in very good form. Other questions? Richard? Mike, yes?
Justice Bell, you have bookended the Matrimonial Causes Act with an inappropriate appointment, but have you any anecdote to share with us about the other end of the Matrimonial Causes Act and the officer then exercising that power in New South Wales? Justice Larkins, I was
Yes. Well, Keith might be.
I think Keith might be.
Keith is probably better placed.
I think even with the absolute privilege that sitting in this place affords me, I won't recount all of the stories I've heard about Tony Larkins, but he was a real character. He had a monocle. He was as they say, a confirmed bachelor. And I don't think he had the prejudices that Hargraves had. But I do remember losing a case very badly before him when I was taking on the Catholic Adoption Agency.
Any other questions? Yeah. Oh, that's Stephen Garten. Yeah, that's Stephen Garten. Yeah.
It's a question about Windia, because another interesting case is obviously Mount Rennie, and obviously one would feel ambivalent about the death sentence, but it's an interesting judgment in the context of its time.
Well, I mean, you raise the fact that his reputation came to be that of a hanging judge, and that was a well-deserved reputation. For those who are not familiar with it, the Mount Rennie case involved the pack rape of a 16-year-old servant girl by a group of youths. My recollection is I don't think any of them was over 20. One might have been, but Justice Windia sentenced them, 9 of them, to death. A number of those sentences were commuted. Some have suggested that Justice Windia's particular sensitivity towards the circumstances of women led him to be especially harsh in dealing with offences of violence committed against women. And there may be something in that. He certainly was harsh. I mean, the other thing about it is the summing up to the jury in the Mount Rennie case would certainly not pass muster today. This was a summing up that amounted to an instruction to the jury that they were going to convict all these young men, and they were young men. And it's interesting, it did invoke quite a large wave of public sympathy, and public concern about hanging young men not yet 20, notwithstanding their violent behaviour.
Any other questions? Excellent. Good timing. Good timing.
Flawless timing,
Flawless
Chief
timing.
Justice.
Thank you. I'll take full credit. Can I just, on behalf of the court, thank you all for your interest in its history. I think it's imperative that we celebrate it properly, document it properly, draw it to public attention next year, which we will be doing. For those of you that are continuing history, as part of our 200th initiative, we're installing what some people call a history wall immediately behind you. So in the outside corridor, about 15 metres, we'll have backlit chronological history of the court, and I'm sure this audience would be pleased to know that the court will itself be conducting tours for senior secondary children, which will begin in this court in the mornings on a regular basis, take in the history wall, involve a visit to some hearings, and probably go across the road where you're about to go, and hopefully we are looking at teaming up to the extent we can practically with our friends at the Legislative Council, because I certainly have a strong belief in civics, and we need to do as much as we possibly can to improve public awareness, particularly on the part of young people, about the role of institutions, parliamentary and judicial. We claim, and I think it's right, that having a stable, strong, independent court is integral to this place remaining a thriving democracy. So thank you very much.
Thank you so much, Chief Justice Keith Mason and Virginia Bell. Thank you for having us here today as your guests. Thank you for bringing to life the people behind each of these portraits. Thank you for the stories. Thank you for the depth of the history that you've unfolded for us. Can I just ask all participants in our conference today to join me in thanking the Chief Justice and colleagues.